Hello, everybody. Really delighted to see so many people here today for this short webinar, which is the third in the series that we are doing. What we're going to do today, or to try and do, is to answer 5 common questions that we've seen coming up time after time in the course of our work and our procurement law practice. I'm Jenny Beresford-Jones. I'm a professional support lawyer and public procurement specialist in the procurement team here at Mills and Reeve. And I'm also joined today by my colleague Claire Gamage, who's the principal associate also in our procurement team, and we work closely together. Claire joined us at Mills and Reeve only a few weeks ago, but it seems like she's been with us much longer already. So I'm really delighted she agreed to jump right in at the deep end and do this webinar with me. I think we've got close on sort of 500 odd people joined already, which I think probably is the largest audience Claire and I have spoken to. And as one of the plus sides of the pandemic is that we can all come together to share our procurement law knowledge in all sorts of new ways that we would never have thought possible before March 2020. So very warm welcome to all of you. We can't see all of you, but we know that you are out there. Hopefully you can all see and hear us. If there are any technical issues, do pop a question in the Q&A box that you should see at the bottom of your screen. And my colleague Lizzie Costello, who always does a superb job for us on the technical side at these events, she'll do her best to help you get connected. Thank you for that, Lizzie. And if you've got any legal questions, do also pop those in the Q&A box. We're going to try to keep the time today to let you all be on your way in 25 minutes or so. So we won't come back to your questions during the session itself, but we will try to contact as many of you as we can afterwards. Just to mention that the session's been recorded, and we'll circulate a copy to everybody afterwards so that you can look at it again if you want to, or forward it on to a colleague. And finally, assuming that the technology works, which hopefully it will, at the end of the webinar, you should see a very short feedback form pop up on your screen. And if you're able to complete that, that would be great, as we really value your feedback, and it helps us to make sure that our future events will be interesting and relevant. And we are planning several more in this series of webinars, particularly around the government's response to the Green Paper on procurement law reform, which I think we're expecting to come out soon. So if that's of interest, do look out for invitations to those events. I think that was all I needed to say by way of introduction. So should we get started on to the first of our 5 in 25? And I think Claire is going to share her thoughts on how we might answer that question. So thank you, Claire.
Thanks, Jenny. Good to be with you all this morning, albeit virtually. So the first question I'm going to tackle, this is quite a popular question we get asked all of the time. Can a public contract be varied to procure additional services? So just going on to the next slide, the short answer is yes. You can vary contracts, and we now have 6 modification grounds which are set out in Regulation 72 of the Public Contracts Regulations 2015. There are also similar provisions for those of you who work in the utilities sector in the utilities regs, and we also have similar provisions in the concessions regulations. So going back to the original question, can we add more services to the contract? The appropriate ground here on the face of it would appear to be ground 2. So just having a closer look at ground 2 in the next slide, if we can meet these criteria, then we can rely on this particular modification ground. So the first criterion is to check are additional services required from the original contractor, as in the entity we entered into the contract with. Secondly, have they become necessary? This is an often overlooked part of relying on this regulation modification ground. Now, there isn't an actual definition of necessary within the regulations or within case law itself, but typically what it would be interpreted as is a requirement to justify why those services are needed as opposed to just desired. So I would always recommend that in your internal justifications, in your audit trail, in the modification notice, you deal with this particular element of this modification ground and explain why those additional services have become necessary. Thirdly, you have to satisfy two particular grounds here. And firstly, that it's not possible to change contractor due to economic or technical reasons connected to interoperability or interchangeability. And there would be significant inconvenience and duplication involved if a new procurement process had to be undertaken. So you have to satisfy both of those grounds, not just one. Further to that, any increase in price, so the cost of those additional services you're adding to the contract, cannot exceed more than 50% of the original advertised contract value. And what I would say there is that's not a cumulative amount, so that's a cap per variation. So then if you find yourself sort of in 12 months' time having to buy more of the same, you would apply that cap of 50%. Again, it's not an aggregate cap. And finally, if you are relying on this particular modification ground, you do have to publish a modification notice in the find a tender service. So again, you would need to explain why you meet all these criteria in that particular modification notice. Moving on to the next slide, I have set out there some examples of kinds of scenarios which are more likely to pass the test or less likely to pass the test for reliance on this ground. So in the first scenario, extending an IT contract where bespoke software has been developed. Now, assuming we're looking to use the same contractor, clearly there could be problems here where you have IP issues, maybe a lot of duplication of work, where if you did appoint a new contractor, there would likely be quite a significant period of transition, which could cause delays to your projects. So there could be a good case here for relying on this particular modification ground. And similarly, if you're using a particular consultancy company for a very complex piece of advice, again, you may need the same personnel, and it would be impossible to, or sort of a lot of duplication in terms of cost to go out and re-procure those services. So again, another scenario which is more likely to pass the test. So scenarios which are less likely to pass the test, where actually the services in question are quite common, then you may not satisfy that element of the test, which is to ensure that there's issues with interoperability or interchangeability, or a scenario where it's actually a different entity which will be carrying out the services. And what I would say here is to be careful of scenarios where a significant amount of a contract is being subcontracted, where that was not originally envisaged. So again, that could be looked at as a circumvention of the rules. So just be careful in those kinds of scenarios. Moving on to question 2.
Thanks, Claire. Yeah, so the second question is on the same theme, really, around variation of public contracts. I'm just moving on to the next slide. We can see that this time we're not looking at down 2, but we're looking at down 3, which is where there are some sort of unforeseeable circumstances that mean that you need to try to vary the contract. Just to also draw your eye onto ground 5 as well, which is an exemption where a modification isn't substantial. And just to draw your eye to that, because I'm going to mention that shortly. And just onto the next slide then. So the third ground, the unforeseen circumstances test. So what do you need to do in order to satisfy this test? Well, first of all, you need to show that the modification, or the need for the modification, has been brought about by circumstances which a diligent contracting authority could not have foreseen. So there's obviously a question about what that means. The second element of the test is that the modification mustn't alter the overall nature of the contract. And on this, there is a question about what that means. And the fifth ground that I drew your eye to on the previous slide says that a substantial modification is one that makes a contract materially different from the one concluded. So there's that language using the concept of materially different, whereas in this ground, they're talking about a modification which doesn't alter the overall nature of the contract. So our view is that the differences in the wording used in these two exemptions means that it's a slightly different sort of test that we're applying here, and that this test here, where the modification is not altering the overall nature of the contract, is thinking about something perhaps slightly broader or more high level than the other Ground 5 test. The third hurdle you have to get over mirrors the one that Claire was talking about previously. So any increase in price resulting from the modification can't exceed 50% of the value of the original contract. And again, as Claire said, that's not cumulative. That is a 50% each time you make a modification, which is helpful to authorities. And as Claire mentioned with the other grounds, you also have a duty to tell the market what it is that you're doing by publishing a modification notice to the find a tender service. There is a question also, it's not expressly set out in the test, but around proportionality. One of the duties that authorities have is to act in a way that's proportionate. And so I think there is a question around whether, if you're relying on this ground, you should only do what is proportionate and amend to the extent that the changes are required because of the unforeseen event. So to show a clear connection between the unforeseen event and the extent of the change which is needed. And then just on the next slide, sort of try to shine a bit of a light on this question of what are unforeseeable circumstances and who is a diligent contracting authority. We don't have time to go through these in detail, but there's a couple of sources of light that we can shine on this. First is the London Underground case, and there's a couple of steers in there that you might look at. So you're really looking at, are the circumstances due to external factors which are out with the authority's reasonable control? And one of the ways of thinking about it is to think that, would I need to make these changes regardless of which bidder has been awarded the contract? If your answer to that is no, and that you're only making these changes in a way that is somehow bespoke to this bidder, it's likely that the need for the change isn't sufficiently objective as to meet the test. And also the Public Sector Directive, which is the sort of parent directive of the public contracts regulations, no longer in force in the UK, obviously, but still an aid to interpretation. In its recitals, it does expand a bit on what the regulations mean by unforeseeable circumstances. So you're really talking about something that couldn't have been predicted despite reasonably diligent preparation of the initial procurement procedure by the contracting authority. And just on the next slide, I'll leave you to have a look at these in your own time, but some examples of things that are likely to pass the test and not likely to pass the test. And particularly at the start of the pandemic, so March, April, May 2020, we saw an awful lot of Regulation 72 extensions relying on the unforeseeable circumstances, and justifiably, on the basis that the pandemic made it impossible to run a new procurement. That seems to sort of clearly, certainly at the start of the pandemic, likely to pass the test. Much less likely to pass the test is simply extending the contract because the authority failed to organise itself to run a new procurement in good time. And I think that was what I was going to say on question 2. Claire's going to have a look at question 3 for us now.
Thanks, Jenny. So another popular question, we get asked this a lot. To what extent can we vary the terms of a template call-off agreement from a framework agreement? And if we just move to the next slide, the answer is essentially that a starting point, of course, is a framework agreement is an overarching set of terms under which future call-offs can be made. So in an ideal world, your framework agreement will include template call-off terms which don't have to be amended each time you call off. But of course, that's not realistic, and it doesn't represent what happens in real life. And in fact, the regulations acknowledge that, albeit in the reverse, under Regulation 33.6 of the Public Contracts Regs, where it says that changes cannot be substantial. So any changes you make to the framework agreement or the template call-off terms cannot constitute substantial modifications. So what do we mean? What is a substantial modification of the framework terms? And I think it's rather entrenched practice now to take that as a substantial modification as defined in Regulation 72.8 of the regulations. So you may be familiar with the press text criteria for a material change, and that is essentially now set out in writing in Regulation 72.8 of the regulations. So when you're looking at the changes you're making to template call-off terms, you need to be asking, are these changes substantial within the meaning of a substantial modification as set out in Regulation 72.8. And indeed, if we just move to the next slide, the Cabinet Office do tend to take this view as well, as can be seen from the 2016 guidance, which was produced here. And what the guidance is saying is that have a look at your framework agreement first, see if it does provide you with some degree of flexibility. How flexible is it? If that agreement is silent, then look at this assessment as to, well, are these changes that we're making, are they substantial within the meaning of a substantial change? Just moving to the next slide, there isn't a lot of case law, unfortunately, on this topic. There are two in particular that I managed to find, and the first one is Lightways, which you may recall. It's a Scottish case, and it was the first ever declaration of ineffectiveness we had in the UK, albeit through the Scottish courts. And in this particular case, the council called off from a framework and awarded a contract to one of the companies within the AMI group. Now, AMI are quite a large group of companies, construction companies, but unfortunately the contract that was entered into was with an AMI entity which wasn't the entity which was actually on the framework agreement. And what the court said, perhaps rather harshly, was that was more than a mere clerical error. In fact, this was an illegal direct award, and therefore a declaration of ineffectiveness was granted in this particular circumstance. Another case which looks at variation of call-off terms and changing the scope of a framework more so perhaps is Medicure. And in this particular scenario, Medicure had failed to obtain a place on a framework agreement to supply locum doctors in its own right. However, had managed to get back through onto the framework by being a subcontractor to another supplier. Now, their challenge was actually predicated on the basis that call-offs were being made from the framework which didn't fit within the advertised scope. So they were basically saying that call-offs were being made for purposes which were not made clear at the outset. Ultimately, Justice Colson decided, well, the description of the framework agreement and the flexibility set out therein meant that those services could actually be called off. So that's quite a helpful case perhaps to look at if you are considering whether you can call off particular types of services from a framework agreement. That's all I wanted to say on question 3. So just moving on to Jenny now for question 4.
Thanks, Claire. So this is a bit of a change of topic. So this question is around procurement challenges. And when we think about procurement challenges, we are all familiar, I think, with thinking about the relationship between the authority and the challenger, the challenging unsuccessful bidder in these situations. But it can often be forgotten that the authority also has a relationship with the successful bidder as well, particularly as under the procurement rules, the authority's duties, so around transparency, equal treatment, non-discrimination, they're owed to all suppliers, including the successful bidder. And of course, if this is a kind of challenge which is happening after the contract has been entered into, then the authority will also have a contractual relationship with the successful bidder as well. I'm just moving on to the next slide. As you can imagine, the successful bidder will always have a good deal of interest in how things proceed in terms of a procurement challenge, there'll be two things particularly that a successful bidder will be interested in. The first is the extent to which its own confidential information is disclosed as part of the hearing, and how confidentiality can be protected. And the other thing it would be interested in, if the contract is signed, will be what happens to that contract, or in cases where the right to go ahead and award the contract has been suspended, the successful bidder will have an interest in the question of whether or not that contract award can go ahead and that contract can be entered into. So what are the duties that authorities have to the successful bidder here? And the main source of guidance is what we all know as the TCC guidance note. And for those not familiar, the TCC stands for the Technology and Construction Court, and that's the section of the High Court which deals with public procurement claims. And this is the sort of Bible as to how authorities and challengers ought to behave when conducting procurement claims. So in relation to this question, there are a few points which are relevant. So on the first bullet there, there's a requirement that both claimants and defendants, so both challengers and authorities, take steps to ensure that interested parties, such as a successful bidder, is given notice of matters that might affect its interest. So the authority obviously has to think about how could the successful bidder be affected by this claim and what interest does it have in it. And on receipt of that notice, an interested party can then apply to court to be represented in the proceedings. And the TCC guide has a lot of detail around the use of what they call confidentiality rings, so that to sort of find a way in which the necessary confidential information can be shared in order that the claimant bidder can bring its claim and have its claim heard, but at the same time the right of the successful bidder to confidentiality can be respected. And confidentiality rings, which is where information is disclosed in a tight ring of people who are allowed to see it, is one of those mechanisms that the court can order. And so moving on, just to pick up a recent case that Claire's been involved in, where this was the interests of the successful bidder were thought about quite carefully in the proceedings. And this is the Draeger safety case, and this was a procurement, I think, for some sort of respiratory safety equipment for use in the fire service that was being procured by the London Fire Commissioner. And Draeger Safety was an unsuccessful bidder who brought a challenge on various grounds, saying that there had been breaches. And the successful bidder was MSA Britain, and they were joined to the proceedings as an observer, and for the purposes of disclosure and for the inspection of their confidential information, so essentially to ensure that they were happy with how the confidential matters were being treated. But interestingly also, they were allowed to actually make representations to the court via letter, giving their views around one of the issues that were in question in the claim, so around compliance with a particular technical standard. So it shows that the successful bidder can get involved to some extent in a challenge between the unsuccessful bidder and the authority. There's a question around the costs of interested parties. If you're joined to proceedings as an interested party, you won't ordinarily recover your costs unless you can show that you were dealing with a separate point in the proceedings that was not being addressed by the defendant or authority. But nonetheless, many successful bidders will choose to join proceedings because they want to have the chance to see and have some say in how confidential information is being used, and to make representations. And so just on the next slide, the other area which is of real interest to the successful bidder, where the contract has been entered into, is where the challenging bidder seeks the declaration of ineffectiveness. Claire touched on this earlier, but it's a remedy which is available in quite limited situations, but it is quite draconian if it is granted, because it overturns the contract from the date that the declaration is made. So obviously that has an impact on the position of the successful bidder, the contractor, whose interests need to be considered. And the regulations do say, and we've put the wording there, when you make a declaration of ineffectiveness, the court is also empowered to make any other order that it thinks appropriate to address any consequential matters arising from the ineffectiveness. And that could include issues as between the successful bidder, the contractor, and the authority, as to how to compensate the contractor who effectively is losing its contract. And our recommendation is that where possible, where you can, it's always a good idea to actually set out expressly what arrangements you will have for ineffectiveness in the contract in the event that the contract is ever overturned. And on to the last question, Claire.
Thank you. Thanks, Jenny. I'll try and tackle this in 2 minutes. Are we able to accept a tender submitted after the deadline? So just moving on to the slide. The place I would always start is the 2013 case of Manova. So in this particular case, what has happened here, 2 of the successful bidders were both universities, and Manova was an unsuccessful bidder and later found out that actually during the first stage of the procurement process, so the pre-qualification stage, both of those universities had failed to attach their balance sheet to their pre-qualification questionnaire. And so Manova basically issued a claim. Now, what the court said was, let's have a look at whether actually that information predated the tender submission deadline, and if it did, and actually the ITT left in enough discretion so that the authority could accept a late submission, then there shouldn't be any breach of the main principles of transparency, equal treatment and non-discrimination. So that's the place I would probably always start if you're in a late tender scenario. Now, of course, there is a distinction between a tender which is a full tender and the full tender is late, or they're just missing parts of a tender. Now, in this particular case in Manova with a balance sheet, you can quite easily satisfy yourself perhaps that that document predated the tender submission deadline, whereas if it's an entire tender, it's obviously going to be much more difficult perhaps to objectively demonstrate that that information was produced well in advance of the tender submission deadline. And clearly the more you go past the tender submission deadline, the more difficult it becomes to then exercise that discretion as the authority to accept that late tender. I'd probably also point out the 2009 case of Leadbitter and Devon County Council. And I think this just demonstrates the importance of how you draft procurement documents. So in this particular case, the council has been very careful to express that the tender submission deadline was a strict deadline. There was no flexibility, therefore, for them to accept a late tender. And what had happened here, Leadbitter realised at about 15 minutes before the deadline, they'd admitted to attach quite a significant part of their submission, some case studies. So at about 14 minutes to the deadline, started to try and upload those documents, however, couldn't. Then ended up on the phone to the help desk about 1 minute to the deadline. And obviously that call straddled the tender submission deadline. And as a result, the council rejected Leadbitter as Leadbitter's tender. What the court said here was because there was no discretion in the ITT, because the reason for the late submission was actually within Leadbitter's control, the council was quite right to stick with its decision to exclude that particular tenderer. So that's quite a helpful case if you are in quite a black and white situation where your invitation to tender is quite clear. Just moving on to the final slide, I hope today was interesting for you, and hope that there's a lot of useful information in the 25 minutes that we've been able to produce for you today. Just a reminder that if you could provide some feedback for us in your forms, that would be really helpful, and also to keep a lookout for future topics and webinars that we will be running. We'll try and get to all of your questions. I can see there's a lot of questions in the Q&A, so we'll try and get back to those as soon as we can, and get something out to everybody. A copy of the slides will be available, and also a recording on YouTube, so do look out for that and pass that on to colleagues if they weren't able to join today. So other than that, I think the only thing to say is thank you for joining us, and hope to see you again soon.